Honorable, the Supreme Court.
Thank you. Thank you. Thank you all. Good morning, everybody. Please be seated. Please go ahead. And please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Amber Neddo as Guardian and Next Friend, ZN, CB, and AB et al. Versus Monsanto Company et al. Case number 24 AP 342. Representing the appellant, Amber Neddo, is Roger Perlstadt. Seated at counsel table with Roger Perlstadt is Hannah Helgas. Representing the appellee, Monsanto Company et al. Is Amir Tehrani. Seated at counsel table with Amir Tehrani is Ian Carlton.
Thanks very much and good morning, counsel. We'll hear from counsel for the appellant first. Of course, please come on up to the podium. And if you would, for the record, introduce yourself, identify your client, and then proceed.
Morning, Your Honors, and may it please the court. My name is Roger Perlstadt. I represent plaintiff Amber Neddo.
Thank you.
As you know, we're here on two certified questions from the federal district courts. And unless this court has other plans, I'm happy to address question one and then question two in that order.
Thank you.
So question one asks whether the term release in the medical monitoring statute includes Monsanto's sales of PCBs to third parties for use in building materials that ended up in Vermont schools. And based on both the text and the purpose of the statute, this court should answer that question yes. So the statute defines release as, quote, any act or omission that allows a proven toxic substance to enter the air, land, or water, surface water, or groundwater. And Monsanto's sales of PCBs fall within this definition of release. It was an act that allowed PCBs to.
Counsel, doesn't the release itself be the act? Isn't that the act, the release?
No, I think it's the act of the defendant. It's an act or omission that allows a toxic substance to enter the air or water or ground. And so I think the act has to be the act or omission of a defendant. And so here, that's the sales. Monsanto argues that the toxic substance has to go directly from a facility into ground or air or water. But the word directly isn't anywhere in the statute. And the statute expressly covers substances like PCBs, like asbestos.
So is it any act by Monsanto constitutes a release?
Any act that allows a toxic substance to enter the air, water, or.
With respect to this substance, then give me an example of something that they did that's not an act, that would not be an act. I'm reading this. It seems to me you could have simply said any act is a release, period.
Well, it's any act that allows it to enter the air, water. So here, an example of something that wouldn't be an act that allows a toxic substance to enter the air is if PCBs could be contained in third-party materials, or if it's sealed a container, buried, never enters the soil or the water, then that wouldn't be an act that allows the toxic substance to enter the air or groundwater. But here, we allege that they knew that PCBs were toxic, that Monsanto knew that it could not be contained in any third-party application, that it would inevitably degrade and off-gas into the atmosphere. And so by continuing to sell PCBs, knowing that that was the case, that is an act that allowed PCBs to enter the air in Vermont schools.
So let's go back to the drum for a minute.
Sure.
Monsanto has a drum of this chemical. They sell it. It sits in a garage for 50 years. Has there been an act that enables a release yet?
If it's not left the drum and it's not off-gassed into the air, then no, that was not an act that allowed PCBs to enter the.
Okay, then the 51st year comes along and somebody pops the top off the thing and spills some on the ground. Has there been an act then?
I think yes. I think it allowed there was an act that they know that the chemicals are dangerous, and especially in our case, if they knew that someone was going to open that and dump it else somewhere, then that was an act that allowed the PCBs to enter the atmosphere.
And is there any temporal limit, or
I don't think
100 years from now, 150?
I think there are temporal limits for liability as a whole. But I don't think the definition of release is where we find temporal limits.
Where would we find the temporal limits?
Temporal limits are well, there would be things like statutes of limitation, statutes of repose, things like that. But I think Monsanto wants to convince this court that that reading the definition of release as broadly as we think the legislature wrote it, any act that allows, they want to convince you that that answering yes to that first certified question, anybody that ever sold a toxic material would be liable. But the statute has numerous other elements besides release that a plaintiff must meet.
So, Mr. Perlson, would you agree that our obligation in this case is only to decide the certified questions and not whether or not there's proximate cause or whether or not there's an actual report here, correct?
Exactly, yes.
Just those questions.
Just those two questions. Yes, Judge Crawford in the district court, Monsanto moved to dismiss on several grounds, including these other things: tortious conduct, causation, whether monitoring is medically necessary. All those issues were raised by Monsanto in the federal court. Judge Crawford has deferred ruling on those. Those are still very much live issues in this case,
But not for us.
but not for you. Exactly, exactly.
I'm
And
not
so
sure if this goes to question 1 or question 2, but is the statute broader than the common law?
the statute mirrors the common law quite closely. And
If there is a common law, correct?
I'm sorry?
If there is a common law.
If there is, which we think there is.
Okay. We'll get to that in a bit.
Where does that come
Okay.
from? You think it's part of the common law. Where is it in the common law?
The common, I don't think there's any reason why Ms. Neddo could not have sued for medical monitoring prior to the statute being enacted. Monsanto has always had a duty not to manufacture and sell PCBs in a tortious manner. That duty didn't suddenly arise in 2022 when the statute was passed. And further, Monsanto has always had an obligation under the common law to remedy harm caused by its tortious conduct. And that's always included the possibility of medical monitoring expenses. Equitable remedies inherently flexible and interstitial, and there's no reason why it couldn't have been awarded prior to the statute.
So counsel, you have a really broad reading of the statute in terms of geography and temporal limits or non-limits or non-geographic issues. So my understanding was that this statute was vetoed twice by the governor as overly broad. Should that inform our analysis as to whether your interpretation is overly broad of the statute?
It can, but I don't think the two veto messages I don't think you read as much into them as defendants want. In the first veto message, Governor Scott flagged concerns with the bill, but certainly the broad definition of release was not one of them. In the second veto letter, he flagged concerns with the bill, and again, the broad definition of release was not one of them. And he just wanted words like, added like significant exposure and significantly increased risk of contracting serious dangers. He wanted words like significantly added. And he said, I think there's a way forward if we can do this. And then he ultimately did sign the bill that gets passed on here. So I don't think you can read too much into his concerns, but his concerns, I think, went to these other elements that are limiting elements on ultimate liability here. This just happens to be an exceptional case, I think, where we allege, at least, that Monsanto knew what this product did. It knew that it could never be contained, and it knew that it was inevitable that it would leak out into the atmosphere and third products. And I think that's consistent with the statute, because the statute covers things explicitly, like PCBs, like asbestos, like lead, that are incorporated into third-party products and then leak out of those products. So under Monsanto's theory of release, the medical monitoring statute wouldn't cover something like a company making asbestos ceiling tiles that were sold to Vermont schools, because Monsanto would say, no, that's a third-party product, and it leaks out of the ceiling tiles, not from our facility. So that's not a release. It wouldn't cover a company making lead-based paint and then selling lead-based paint to toy companies, and then the lead paint flaking off of toys and polluting Vermont children's homes. Monsanto's theory wouldn't cover that, but I think the statute is clearly intended to cover that. The purpose of the statute is to help Vermonters get medical monitoring to facilitate the early detection of treatable diseases when they've been exposed to high levels of a toxic substance. So when people like Miss Neddo's children need medical monitoring because of someone else's tortious conduct, the point of the statute is to shift the costs to the party from the victims, from innocent victims, to the tortfeasor. And so I think reading the statutory definition of release that we think is worded very broadly furthers that purpose. And without the dangers of excessive liability because of all the other guardrails on the statute, the other elements required besides release, but limiting the definition in the way that Monsanto argues does not further that purpose, and we don't think it's consistent with the text.
But Attorney Persta, I guess my issue here is, as you know, in statutory interpretation, this court has to read the statute as a whole. And how I read it is the word release cannot be separated from its contextual phrase, which requires release from a large facility. So tell me how to reconcile that with your interpretation that you're advancing.
I think from just means point of origin. And the statute just says that a person shall have a cause of action against a person who is the owner or operator of a large facility from which a proven toxic substance was released. So it was part of the changes made from the St. Gobain common law test was to add this large facility element. And that was done to protect small businesses, I think. So then when they insert this idea of large facility, they need to say from which it was released. And I think that just means it's the point of origin that from does not mean directly. They could have easily said directly from a facility into the air. And again, I think if you read too much into from, you're ignoring things like asbestos and lead and PCBs that are incorporated into other products and ultimately leach out.
I'd like to direct your attention back to the common law for a minute. Other than Judge Crawford's commentary on what the common law was, can you point me to any decision of this court that indicates that medical monitoring was part of the common law prior to the enactment of the statute?
I think that the two future medical monitoring cases, we cite Herbert v. Stanley from 1964 and Howley v. Cantor from 1933, which talk about future medical expenses emanating from a tortious accident. And so I think medical monitoring can be considered a part of that. And then
There was
also
actual injury in those cases.
I'm sorry?
There was actual injury, physical injury in those cases. correct?
There is, but I think the medical monitoring common law cases use an interesting hypothetical, I think. A pedestrian is knocked down in a crosswalk by a negligent motorcyclist. And understandably shaken, they go to a doctor's office and the doctor says, oh, we should do a bunch of tests on you to make sure you don't have any internal injuries. They do a bunch of tests. The tests all come up negative. But under the common law, the pedestrian would still be able to seek recovery of the costs of those tests because it was still a result of the negligent conduct of the tortfeasor. It was a cost imposed on the victim. And so I think quite reasonably, and I think the common law medical monitoring cases are quite thorough and convincing. And I think that hypothetical helps illustrate why.
But that's a little different than if someone was going to the doctor to see if they'd been hit, which is
Right, but that's where the element of Ms. Neddo will have to establish in the federal court that her children were exposed at a higher level of PCBs than the general population, and that medical monitoring is medically necessary. She will have to establish all those things in front of the district court, the federal district court, before she can get a medical monitoring remedy. So it's the medical monitoring common law cases distinguish between sort of chance of harm, future chance of harm. Maybe you're going to be hurt later, maybe you're not. So we'll find an amount and then deduce it by the probability that you don't get it. And most of the courts say, no, that's not it. But they distinguish medical monitoring and saying, no, you have incurred, because of this increased exposure and the necessity of medical monitoring, you have incurred this cost and you are entitled to recover it. I'd like to reserve some.
Let me ask you a question about the certified question 2B, which is about a defendant who sold a toxic substance to a third party before the statute was enacted. Is that the time we should be looking at, or should we look at the time of exposure?
I think you should be looking at time of exposure, because the point of the statute is to cover current harm from whether some environmental contamination happened in the past, there is ongoing harm. And so if there is ongoing harm, then the statute will apply to that time.
So it would be, so no, doesn't make a difference when it was sold. It makes a difference when the person happened to be in a place where they had exposure to a toxic.
Exactly. And I think the federal RCRA cases that we cite make this point pretty explicitly, that the RCRA is not retroactive because it imposes liability for present and future conditions resulting from past acts. That's from the Northeastern Pharmaceutical case out of the Eighth Circuit. And I think those cases are analogous to here. The PCBs are in the schools now, and Ms. Neddo's children need medical monitoring now. And the Vermont legislature wanted to shift the costs of that medical monitoring. Somebody has to pay for that medical monitoring. And the Vermont legislature wanted to make it the liability of a tortiously acting company, not just any company, but a company that acted tortiously, and that tortious conduct caused this high level of exposure that makes medical monitoring necessary.
What's the tort?
I'm sorry?
What's the tort? Which one?
Negligence. I think
Well, you talked about it as an intentional act, Monsanto, that they were releasing it intentionally, knowing that it was harmful. Would that be negligence?
yes, I think it could be an intentional tort as well. I mean, I think the point is you have a duty not to hurt you have a duty to act reasonably and not hurt other people. And we think Monsanto acted very unreasonably in this case. I'd like to reserve time if it's possible.
Yep.
Thank you, Your Honor.
Thank you. Counsel for the appellee, please. Before you start, introduce yourself and identify your client.
Good morning, Your Honors, and may it please the court. Amir Tehrani from Monsanto, Solutia, and Pharmacia. This court should answer both of the certified questions no. On the first question, a manufacturer's sale of chemicals to a third party in a commercial transaction does not constitute the release of those chemicals within the meaning of Vermont's medical monitoring statute. On the
Do you agree
second
that
question.
The medical monitoring statute definition of release is fairly broad?
The definition requires that the proven toxic substance enter the air, land, or water surrounding the facility from which it is released. So the definition is focused on a direct emission into the environment. There must be a proven toxic substance that enters the environment, and it must enter from the large facility. So the plain statutory language here is clear, and that reading is confirmed by the statutory context for the enactment of the medical monitoring statute. It was part of a
Weren't the PCPs from Monsanto?
PCBs were manufactured by Monsanto, but they did not enter the air, land, or water from old Monsanto's manufacturing facilities in Illinois and Alabama. Old Monsanto sold PCBs to third parties, which then incorporated the PCBs into finished products that were installed in Vermont schools and that allegedly emitted PCBs into the air in Vermont schools. So the release occurred in the Vermont schools. It did not occur in Alabama or Illinois, where old Monsanto had its manufacturing facilities.
But wouldn't that be more important for, say, a jury or a court to decide as part of the proximate cause component of the statute, not as the definition of release?
There are additional causation elements to the medical monitoring statute, but that doesn't obviate this court's obligation to construe the plain language of the threshold liability provision, which imposes liability on the owner or operator of a large facility from which a proven toxic substance was released. So the release must be from the large facility. The legislature knows how to impose liability based on commercial sale. It did that in Section 2 of Act 93, which is
And go ahead, finish your thought, and then I just want to follow up very quickly with that.
which was the bill that also enacted the medical monitoring statute. Section 2 imposes liability on any person who manufactured for commercial sale a hazardous material. So that's an example of the legislature focusing directly and expressly on manufacturing for sale. It did not use that language in section 1.
And Attorney Tarani, the statute was also adopted alongside the waste management statute, was it not? And in the waste management statute, that was also amended to address the sales to not to third parties, but the sales directly of any toxic chemicals. Is that accurate?
That's exactly right. So that is section 2 of Act 93, where the legislature amended the Waste Management Act to impose liability on any person who manufactured for commercial sale a hazardous material. That's an example of the legislature focusing on commercial sales. What it did in section 1, by contrast, was focus on releases from a manufacturing facility, which would be, for example, emissions from a smokestack or leaking from a pipe into the surrounding soil or water. The legislature also knows how to
In
create a cause of
follow-up to that, how do you respond to the lead-based paint and asbestos argument that council made?
Your Honor, there are more than 800 proven toxic substances covered by the medical monitoring statute, which incorporates CERCLA's federal definition of toxic substances.
Well,
So
the definition of release is much more specific than the definition in our medical monitoring statute, is it not?
it is, Your Honor, but with respect to whether the statute would cover lead or asbestos, my point is that there are literally hundreds of different types of chemicals that would be covered by the medical monitoring statute. And there's no reason to distort the plain language of the statute to cover lead or asbestos when this is a broad statute that has substance and meaning to it and will provide a meaningful remedy to plaintiffs in appropriate cases where there is one of these more than 800 proven toxic substances released into the environment from a large facility. The legislature knows how to provide a cause of action for PCB emissions in public schools. It also did that in the Waste Management Act.
I don't mean to interrupt you, but this isn't, we're not talking about a cause of action for this. We're talking about a remedy, correct? This is a remedy that's available to them when there is a cause of action.
No, Your Honor, this is a freestanding cause of action. The plaintiff must prove the 6 elements specified in the statute, and when that occurs, may be entitled to the medical monitoring remedy. But it is a freestanding cause of action, which is a distinction from the medical monitoring remedy that Judge Crawford predicted would be available under Vermont common law. And to jump to the second question is one of the many reasons that his prediction does not solve the plaintiff's retroactivity problem, because he predicted that at most there would be a medical monitoring remedy under Vermont common law. This is a medical monitoring cause of action.
But this still requires a tort.
It does require a tort. That's one of the additional elements. The plaintiff must demonstrate that the release was caused by tortious conduct. But as a threshold matter, the plaintiff must demonstrate that the owner or operator of a large facility released proven toxic substances from that facility. That's the threshold showing that must be made. The legislature has created a cause of action for PCB emissions in public schools in the Waste Management Act. It did that in 2021 and in 2022 when it amended and then further revised the definition of release in the Waste Management Act so that it expressly covers the emission of PCBs into the air in public schools. If the legislature had wanted the medical monitoring statute, which was also enacted in 2022, to provide a cause of action for PCBs, it would have done so expressly. It was addressing a different problem in the medical monitoring statute. It was addressing the release from large facilities into the environment. Those are the facts that were top of mind for the legislature because those were the facts in Sullivan versus Saint-Gobain, which was the impetus for the legislature's enactment of the medical monitoring statute. That case involved a direct emission into the environment from Saint-Gobain's manufacturing facilities where PFOA seeped into the soil and groundwater. And as this court observed, the legislature didn't simply adopt at face value all aspects of Judge Crawford's medical monitoring test from Sullivan. It narrowed that test in response to the governor's concerns about overbreadth and imposing undue, unwarranted liability on businesses in Vermont. It strains credulity to suggest that at the same time, the legislature narrowed Sullivan's medical monitoring remedy so that it applied only to owners or operators of large facilities, that at the same time, it dramatically expanded that remedy so that it would apply not only to direct emissions at issue in Sullivan, but also to sales of commercial products in arm's length transactions. That defies common sense, it defies the legislative history, and it ignores the fact that the legislature was responding to multiple vetoes premised on concerns about overbreadth. If I might turn to the second certified question, even if the medical monitoring statute did apply to sales of toxic substances, it would not apply retroactively to old Monsanto's decade-old sales of PCBs because
Would we look at the time of the sale or would we look at the time of the exposure? Aren't those two different analyses?
they are two different inquiries, Your Honor, but this court's retroactivity jurisprudence is focused on the date of the defendant's conduct. We know that from this court's decision in Carpenter versus Vermont Department of Motor Vehicles, where the court explained that a measure is retroactive where it imposes new obligations, new duties, or new disabilities in respect to transactions already passed. So we need to identify the transaction. And here, the relevant transaction would be old Monsanto's sales of PCBs between the 1930s and the 1970s.
But to follow up on Justice Eaton's question to the appellant, that if there was a bucket of PCB in someone's garage and nobody opened it and nothing happened for 50 years, and then it was either spilled or opened and it was released, how would you say that, how would we analyze that exposure versus sale?
The trigger for liability under that hypothetical would be the sale, because that is what the medical monitoring statute imposes liability for on plaintiff's theory. The plaintiff is arguing that a release is broad enough to encompass a sale. So if old Monsanto is liable under this statute, it is because it sold PCBs decades ago. And that cannot be a basis for liability where until 2022, there was no medical monitoring cause of action or remedy under Vermont common law. We can't change the rules of the road for sales that happened decades ago. That's fundamentally unfair to defendants, and it's inconsistent with this court's test in Carpenter, which looks to the transaction at issue and whether new duties, obligations, or disabilities are being imposed on that transaction. And here, if the medical monitoring statute were applied to old Monsanto, that would impose new substantive obligations that did not exist in 2022. The federal district court's decision in Sullivan doesn't help the plaintiff on this score, because that was merely a prediction by Judge Crawford about the content of Vermont common law. It was not binding on this court. It was not authoritative. That's precisely why the legislature acted in 2022 to codify a medical.
If that was a part of Vermont's common law, does the statute alter what that common law was, according to Judge Crawford?
Yes, the statute goes far beyond even Judge Crawford's view of Vermont common law, because he predicted that there would be a medical monitoring remedy available for direct emissions into the environment, which is what Sullivan related to. It was emissions of PFOA into the environment. The plaintiff is urging this court to recognize a medical monitoring remedy based on sales of chemicals in arm's length commercial transactions. Not even Judge Crawford suggested that there would be a medical monitoring remedy available under those circumstances. There's no hint, there's no suggestion anywhere in Vermont common law, state or federal, that suggests that there was ever a medical monitoring remedy available before 2022 based on the sale of chemicals from a manufacturer to a third party. That is a textbook example of retroactive lawmaking if it were to apply to old Monsanto's decades-old conduct. And we know that the legislature did not want this measure to apply retroactively because it did not include retroactivity language in the statute, even though in Section 3 of Act 93, it included retroactivity language.
So does your argument fail if we adopt the appellant's definition of release?
No, Your Honor, because even then, the inquiry is whether there was a pre-existing common law right under Vermont law to recover medical monitoring based on a sale. The plaintiff's definition of release is that it's broad enough to encompass a sale, but there was no hint, no suggestion in Vermont common law, not even from Judge Crawford, that there was a medical monitoring cause of action or remedy before 2022 based on the sale of chemicals in an arm's length commercial transaction.
Thank you very much. Your time has expired.
Thank you.
Does the appellant have any time?
Appellant has no time remaining.
Okay, thank you both. Please call the conclusion of the hearing.
The next hearing for the court is scheduled for 9:45 this morning.